Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and its honorable court.
Please be seated. Good morning, ladies and gentlemen. Welcome to the Fifth Circuit Court of Appeals. We have 3 cases to be submitted today on oral argument. And we begin with United States versus Naidoo. Mr. Starrett.
Good morning. May it please the court, counsel. I'm Richard Starrett, and I represent Terrell and Naidoo this morning. What I'm about to say is relevant to my argument. I was a prosecutor for 28 years in the Southern District of Mississippi. I investigated and prosecuted child pornography cases along with others. Before that, in my younger days, I was a court-appointed guardian ad litem for children in suspected child abuse cases. I have 6 children and 6 grandchildren so far. I love children. I agreed to represent Mr. Naidoo, who has been charged and convicted with possession of child pornography and is now serving a 14-year sentence. I agreed to represent him because I think that everyone is entitled to a fair trial, and those rules don't disappear or get diminished when the charge is...
It's time for you to move on to the issues in the appeal.
Thank you, Your Honor. The government, and my point in that was that the government overstepped in this case and charged Mr. Naidoo and put on proof against Mr. Naidoo. The indictment charged the violation of 18 U.S.C. 2252A4B, which means that the government has charged him with possession of one or more images of child pornography on a device. They charged 3 counts, so their burden of proof was to prove one image of child pornography on 3 different devices. What they did at this trial was to introduce testimony, descriptive testimony of images of child pornography and actual images 22 times throughout the course of this trial in 27 different exhibits containing multiple images of child pornography.
And the case law perfectly well allows that. It was a very small percentage of the images that were being charged, wasn't it?
Well, yes and no. I'll get to Caldwell and the 3 videos that Caldwell authorized in a moment. But I want to make my point that they put in over 100 images of child pornography in this case, and that's not the only problem with this case. There's a far more serious problem, which is that they chose the vilest, most extreme example of child pornography they could find in their investigation and charged him with that and introduced it, and it went back to the jury room. I'm talking about Exhibit G64. G64, G64A, and G64B. Now, sometimes as a prosecutor, when you have evidence that you want to introduce because you want to get your conviction, but you know that this approaches the line at least of too prejudicial, too extreme, the prosecutor will go to the judge and say, Judge, we think this is permissible and allowable. I just want to make sure that we don't make a mistake here and show that to the judge. That conversation didn't happen in this case. If it had, the conversation would have been, Judge, take a look at G64. We think it's admissible, but we don't want to make a mistake. And the judge would have said, that's awful. Do you have any other evidence that will establish that Mr. Naidoo possessed child pornography other than this? And the answer would have been, yes, Your Honor, every other piece of evidence in our case is less extreme than this, but we want this piece of evidence. That conversation, that pre-clearance, just out of abundance of caution, the prosecution blew right through that. They put in G64, which is described in the record, and the description is just, it's awesome. Looking at the photograph.
I assume there was an opportunity for Mr. Naidoo's attorney to argue that on closing argument to the jury that these were more extreme than the run-of-the-mill images.
That's a legal issue, Judge, that went to the trial judge, and the trial judge shut them down. He said, this is coming in. They filed pretrial motions. They objected throughout the trial to the introduction of this child pornography.
My point, you misunderstood my point. It was objected to. I'm talking about on closing argument to the jury. There was every opportunity to argue that maybe these particular images were more extreme than many or most of the others.
With respect, I don't think that is a good argument to the jury, that this is so terrible that you should do what the judge should have done.
Okay, but the argument that he was making was, I didn't do any of this. So from the, I don't know if this is a fair term, but the least provocative to the most provocative, whatever that may be, because all child pornography is inappropriate and bad, but that isn't the issue. It isn't, well, I was only looking at this one thing and not this other. It was, I didn't do any of this. My wife set me up. That was his defense, right?
I agree completely.
Okay, so that does not seem to be altered by showing A versus B.
Well, then the question is, why do it? If the government only has to show that he possessed child pornography, why seek out the worst image they could find?
Well, because, you know, people take pictures of their little baby, and maybe that is not child pornography, and maybe they don't understand what child pornography is, and so on. And so explaining to the jury is something the government wants to do. And Mr. Naidoo can say, I didn't look at that. And in fact, the extremism of it helps him say, I would never look at something that horrible. It's just revolting to me.
Again, I don't think that's a persuasive argument to the jury. I don't think he should have been in the position of that evidence going back to the jury room and then having to say to the jury, that's so extreme, I couldn't have done it. That's just not a persuasive argument.
Well, then let me ask you about the expert witness, because that seems to be tied to that point of he couldn't have done it. First of all, the district court said they didn't give me the expert report. They just described it to me. Why would you all not give the expert report to the district court?
I don't know why that wasn't done, but the judge said both parties are in agreement with this statement. Or, as a matter of fact, he took the prosecution's summary of what the experts were going to testify to and said, this is what we're talking about. Both sides said that's accurate, and he made his ruling based on that.
Okay, because, I mean, it's a motion in limine. You still have the opportunity to try to go past that, and it would seem like the details of what the expert's going to say are kind of important. Because just an expert coming in and saying, I don't think this guy would look at child pornography isn't very helpful. But if he did testing and other things, that could be helpful. So why would you not present, not maybe you personally, but your group, not present that?
I don't know why that wasn't done. And the argument that is that the description of what they would have testified to is sufficient for the Court of Appeals to decide whether or not he should have allowed that in, particularly in light of the way things played out at trial. Remember, this was denied, and when it was denied, the judge says neither side's going to get into motive. All right, you're not going to get into motive, and that was the rule. That's what we had to try the case under. They had to try the case under. And I want to further that point in just a moment, but I want to go back to one thing. There was a mistake in my brief when I said that Exhibit G64B. A video was played to the jury, this really vile one that I'm talking about. It was actually a storyboard. G64B was the storyboard. That was displayed. My brief said the video was displayed. That was not. That was an error on my part. But it really doesn't matter because it all went back to the jury room. All of the images of child pornography went back to the jury room.
Okay, I want to go back, though, to the expert because I want to make sure I understand that. Did any of the experts actually test his reaction to child pornography, whether it made him excited or not? There is such testing.
Sure. I do not recall.
In the world. So I'm asking whether that was done.
No. Doesn't
that make a difference? Because, I mean, easy enough to just say, oh, you seem like a nice guy. I don't think that you would look at child pornography. That doesn't seem to be particularly helpful or particularly valid. Whereas the testing that can be done by psychologists on things like that, and I mean, I'm a psych undergrad, so I'm just calling upon my memory of that knowledge that I gained in college, could demonstrate that it's something that the person can't really lie about. You know, it's almost like a lie detector test.
I agree, Your Honor, and I don't know.
Okay.
They formed their opinion, they gave their opinion. What went back to the jury room, the prosecution wanted a device to go back to the jury room. I want to make this point clear. The judge said, I'm going to send the jury my laptop. The prosecution said, let's send our own laptop. And the judge said, well, I'll decide how I'm going to send that back. What he ultimately ended up doing was instructing the jury that if you want to view any of this material, all you have to do is go to the courtroom security officer directly, ask for it, and he'll give it to you. All right. So there's nothing to say. The government can't say that any or all of this was not viewed, including the G64 that was not played for them in the courtroom. That's extremely prejudicial. That's why I say what they did was not only deliberate, but it was so risky. You put in thousands of images of child pornography and send it back into the jury room, and you exercise no control over what they're going to look at. So you have to assume that they could have looked at all of it.
Mr. Starrett, you spent 10 minutes on this. I believe we have that issue. If you have any other issues,
I do.
You might want to use your time wisely.
Thank you. The court excluded the expert witnesses, saying neither side could be able to put in proof of his motive. It's just not relevant enough in this case. But when the case was tried, the government put in two narratives that they say they were found on a site that one of his devices had accessed, not a charged device, and it was not downloaded to anything. It was the government that downloaded these stories about children having sex with adults. The defendant objected to that, and they said, wait, Judge, this violates your pretrial ruling. You told us that we couldn't prove that he didn't have a motive, and now you're letting them prove that he did have a motive because he is the type of person who looks at children engaged in sex. The prosecutor said, here's why it's important. This shows it was something he had interest in, which then goes to who might be the one knowingly possessing the child pornography in this case. The court said the same thing. The question here is whether or not this defendant knowingly visits a website which contains stories about child pornography and whether that makes it more likely than not that he knowingly possessed child pornography. Those two statements are the definition of propensity evidence. That is the type of stuff that you should not be permitting to prove he is the bad type of person. A type of person who would read stories about children having sex is the type of person who would possess child pornography. And beyond that, the evidence itself should not have been coming in. But when it did come in the government's case in chief, the defense said, okay, now they clearly have opened the door. Let us put our experts in to say, no, he does not have a motive or an interest in looking at children engaged in sex. And the judge said, no, I'm not going to let you do that. That was unfair. And it not only was an error that happened, it was never emphasized or commented on. This was a fact used by the government in closing the argument as a reason to convict the defendant, that he was the type of person who would access stories about children engaged in sex with adults. This error continued, and it got compounded when the court gave a 404B instruction about these stories over the defendant's objection. The defendant said, look, there's no evidence of motive except what you let the government put in. We don't want the jury focused on motive, and this instruction focuses them on motive to our detriment. Judge says it's a standard instruction that's coming in, and he gave the instruction which had no bearing on any of the issues the jury should have been considering based on the court's pretrial ruling. That was error. Further, that instruction came in after... I've already said the defendant objected to that instruction. The next instruction that was an error was the instruction about on or about. The defense made an argument about count 2 saying the defendant could not have possessed the card at issue in count 2 because it says he possessed it on July 10, 2017. He was 500 miles away. He couldn't have possessed it.
Did it say on or about, or did it say on?
It said on or about, yes, sir. It did say that.
You misquoted that. And, of course, the case law allows on or about.
Yes, it does, and the jury instruction followed the case law. The problem with it, though, was it came after the closing arguments had been made. The defendant says there's a problem here with this indictment and this count. The prosecutor got back up, and here's his words. The defendant plugged the SD card into the ACES, a device, on December 8, 2015. The date charged was July 10, 2017, but the prosecutor saying to the jury, the defendant plugged the SD card into the ACES on December 8, 2015. The defense just told you about, well, Terrell wasn't there on July 10, so he didn't possess it. Well, that shows he did when he plugged it into his ACES laptop. That's clearly an argument where he's saying to the jury, don't worry about it. It doesn't matter whether he possessed it on the date charged, July 10, 2017. He possessed it on December 8, 2015. The jury, and that's what the jury was considering. The jury's confused about this date. It had to be this count. The jury says, are we considering the verdict based on the dates in the indictment? The judge says to the lawyers, I'm going to give them this honor about instruction. The defendant says that we object. It's too late. We based our oral argument on our closing argument on without that being in there, and it clearly would suggest to the jury that you are endorsing that argument made by the prosecution about December 2015. I see my time is up.
Yes, thank you, Mr. Starrett, and you've saved time for rebuttal. All right, Mr. Paradiso, and if I'm mispronouncing that, please correct me.
Your Honor, that was correct. May I begin?
Please.
Thank you, Your Honor. May it please the Court, my name is Ralph Paradiso. I represent the United States government in this case. Judge Haynes, in your question of whether or not one of the experts did any testing related to the defendant looking at child pornography, the answer is no, and you can find that in the record of appeal at pages 1207 and 1217.
But we don't have the actual report.
No, Your Honor,
right?
Not part of the record.
So we don't. Okay. And would that have made a difference if they'd done the testing?
Not for this, Your Honor. Not for the charges the defendant is facing in this case.
Well, I'm having a little trouble understanding that because I could see, if I'm selling pens, that doesn't necessarily mean I use the pens, but I might have a box of pens in my hands because I'm going around selling them. So I can understand that you can possess something and not necessarily sort of use it. But here it seems the whole case is focused on he's watching this stuff, not that he's possessing it and handing out to his friends, but that he is watching it. And why would you watch child pornography if it does not excite you? I mean, I'm just trying to understand that.
Yes, Your Honor. The statute does not, the defendant was not charged with watching the videos, just possessing of it, for just a minor distinction. Additionally, the statute is a general intent crime, so the knowledge is the fact that he actually has it, not his motive or bad motive behind it. Or even if, as in the case in the Fox, where the defendant tried to claim a good motive of why he had it, that he was trying to do his own investigations, the court said that doesn't matter. You possessed it, and the statute says you possessed it, and therefore you're guilty. In this case, the defense was trying to add a layer of mens rea on top of that, saying, well, not only that, jury, you have to figure out why he had that.
Okay, but I think given that the case involves his wife being the one who's concerned about his love of adult pornography, she's going around cleaning out the house while he's gone of the adult pornography, and then she discovers the child pornography, she says. And he says she's doing it to set him up. Doesn't it matter whether he actually likes the child pornography as opposed to whether he just decided to buy some and put it in the safe?
No, Your Honor.
I mean, for the facts of this case, the jury's having to decide who's telling the truth between the wife and the husband. And isn't that part of that assessment? What is logical? What makes sense? I mean, just like you all put evidence that some of this stuff had been there before she moved in. So that's to support her testimony. So why can't he support his?
Yes, Your Honor, and he was able to support his. The defendant, he just couldn't wrap it in the package of expert witnesses like he wanted to. So in this case, as came out during sentencing, and the district court was aware in his great latitude that he's afforded, he understood that what these experts were going to do is just repackage self-serving hearsay and put that before the jury with a stamp of expert approval on it. In this case, as came out during sentencing, the experts, specifically Dr. Neiman, only talked to the defendant and performed no tests whatsoever, and she was going to give everything he said on the stand to the jury. Additionally, Dr. Lott, 2/3 of his report and his testimony is related to what the defendant told him, what Dr. Neiman told him, what the defendant's family and friends told him. He did some limited personality tests and things of that nature, but if you go in the record of appeal at around page 1216, he starts to say again
But the test reference was a personality test, not, to just use a generic kind of phrase, an excitement test.
No, he did not do the PPG test where you look at child pornography and you measure the stimulant to the person. He did not do that. What he did say, Dr. Lott, around Record of Appeal, page 1217, that if he would have known the amount of images the defendant possessed, he would have changed the testing that he did, but his evaluation was based on what the defendant told him. So the district court, in its great latitude, realized that what the defendant was trying to do is repackage self-serving hearsay and put that on with an expert saying this is the truth. The defendant was allowed to put on his argument that he was not the one who possessed it or he didn't have a motive, that it was the wife trying to set him up. He cross-examined the wife. He testified himself. He put on two fact witnesses who talked about the wife and her motive. He put on a forensic expert to try to rebut the government's computer forensic expert. So he was able to put forward his argument against motive. The district court just wouldn't let him put the experts on, knowing that they were just trying to put forward self-serving hearsay.
Okay, then why the Christian Archive stories when the court says whether or not this defendant knowingly visits a website which contains story about child pornography, whether that makes it more likely than not that he knowingly possessed child pornography. I guess I'm not understanding why that would be all right and then the experts are not.
Sure, because with an expert testimony, Your Honor, comes the jury will give it more weight, and that's one of the things the judge was concerned with, that the jury would give an expert more weight than a fact witness or factual evidence that was put forward in this case. Those stories came off of devices that were in the defendant's possession back in the day when the wife wasn't there. Additionally, on that device and around the same time the stories were there were access to a website for Dragon Con, which is a comic book convention. In the ACES computer, I believe, were pictures of the defendant at Dragon Con or Dragon Con brochures. Additionally, in that ACES was the defendant using his email accounts and some other personal information, and some of those same things were found in other areas where child pornography was found, not on the charged devices, but on other devices that had shown that child pornography had been accessed, all before the wife came. So all that went to go show that it was the defendant who was knowingly doing this and not the wife. Also, it went to go show...
But doesn't that support a motive idea? I mean, I can see showing that the child pornography was there before she got there. I absolutely get that. But showing that he was reading stories about child pornography that are not themselves child pornography means that everybody who reads a story on child pornography, which you probably have in this case, means that you're interested in child, you're looking at it. And that doesn't seem to me to mesh. I mean, we all read stories on things we have no desire. We read murder stories. That doesn't mean we're all going to go commit murder, I hope.
Yes, Your Honor. The 2252 does not penalize you for having a bad motive. It penalizes you for possessing an item. And what the defense was trying to do is add that extra element on that you, jury, now have to figure out why he did this, and did he have a motive to do it? And that's not what the... No,
I'm talking about the story. He's objecting to the fact that y'all put on the story to show that he was interested in watching child pornography, and I'm asking how that does show that we all read stories about things that we would not do, and I'm just using murder as an example.
Yes, Your Honor, I apologize. I misunderstood the question. The government wasn't putting it on to show that he was watching child pornography. It was putting it on to show that he was the one who was knowingly possessing the child pornography back in the day of 2014. He also had the opportunity to do it back then, and he can't claim that it was a mistake of fact, that he accidentally downloaded child pornography while he was downloading adult pornography, and that was a issue that the government had to be aware of or be on the lookout for, as the defense in their brief had noted at one point, I believe on page 21, that sometimes you can download illegal stuff when you're trying to download illegal stuff. So these are all issues that the government had to be aware of, and that's one of the reasons, or the potential reasons, that evidence was put on. So in relation to that, Your Honor, the district court did not err in its exclusion of the mental health experts or the admission of the narratives in the case. I also want to move on to the number of images and the images that the defense had indicated. You all should have a copy of the government's chart. It was a corrected version of a chart that was for Table 1 in Government's Brief 30. And the reason that was put in there is the original table had indicated that G64 alpha was played, and it was not played for the jury. Old Chief gives the government great latitude in what it can present before the jury, and that's what the government did in this case. On one device, the 64 gigabyte SD card, the defendant had over 90,000 child pornography images and over 190 videos. In those images and some of those videos, the terminology of what they're used or their names are not indicative of child pornography like I see a lot of times in my cases. They were just letters or numbers put together. So the government had to show child pornography to the jury. The government was very judicious in what it tried to show them. We limited what we showed them. We only showed 10-second excerpts of 3 videos. Some of those videos were 10 minutes long or 25 minutes long in their entirety. We also limited what we actually published to the jury. I believe, if my calculation is correct, we only published 8 pages of child pornography to the jury, and we would generally just put it down, 1,000, 1,000, take it off, and ask questions to the expert who was testifying.
But were these the worst of the group?
The one that the appellant has spoken about, it is a horrific video. However, that's why the government did not show it, but it is also indicative of other videos and images the defendant had on his devices. So in that instance, we just showed a storyboard, which is computer generated. It just goes through the video and it does a 5x5, just pulling out images. And that's why we had to have, so not to show the jury the video, we had to show at least the storyboard and have him describe it in a limited fashion. So that's what it was, but it was indicative of other type of images and or videos the defendant had in his possession.
Mr. Starrett makes the point, and I'm mentioning it so you can comment on it, that the jury could still go back in the jury room and watch any or all of the images or the videos. Is that right?
Yes, Your Honor, but there is no indication that they ever did that. And when he was speaking of the government and the court and the computer use, the government was letting the court know that just because once the court plugs that into its own device, child pornography would be on its system. So the government always brings a computer with us that is free so that the jury can watch it if they want to.
I guess I'm a little unclear why you admit an exhibit into evidence that you don't want the jury to watch.
So we admitted into evidence, Your Honor, because the jury has to make their own determinations of what is child pornography and what is not. So that
right, but that would assume they watch it. I mean, when an exhibit is admitted, then there is the assumption the jury will review it. Now, I understand. I've been a trial judge. I've seen hundreds of pages admitted, and the jury comes back after 45 minutes. They obviously didn't look at it, but they could have. And that's why you still have to examine, whether that was properly admitted.
Yes, Your Honor. And in this case, the judge, the defense filed a motion to limit what the government could produce. The government replied, and the judge weighed the evidence in front of him, and in his broad latitude and discretion, decided that the government, what the government was put forward was enough. He even admonished the government, don't put on too much, don't go overboard. And the government realized that, and we tried to be judicious where we could. The number of images that had to be put forward in this case, one was because we had to show that it was the defendant and not the wife, and the images that we did show to the jury were some that were on each device that was charged, and then to show the connection between the non-charged devices that were present in the home prior to the wife being there and present in the home post the wife leaving, to show that this was the defendant and not her, to rebut his defense that he was raising. Additionally, in relation to the 404B instruction in this case, the court gave a 404B instruction related to the narratives, and the defense objected. However, in that case, or in this situation, what the court did was it looked at this was similar acts evidence, and it put them forward, gave the standard jury instruction, pattern jury instruction 1.32 to the jury. And as this court in Pampa had said, that a pattern instruction properly instructs a jury on permissible uses of extrinsic evidence. Here, the stories went not just to his knowledge of using the device, but his opportunity and his absence of mistakes, since it tied into different things that he was doing back in the day. In relation to the jury question argument that the defense has raised, excuse me, Your Honor, here, as this court knows, that the trial judge has discretion before or after to instruct the jury. And in this case, when he realized that there was an inadvertent mistake, which the defense was aware of because the charge sheet and the indictment said on or about in it, but the judge inadvertently did not give that instruction. He recognized that, and he then went back and gave the instruction. He used the pattern jury instruction, and that's what he gave the defense. I'm sorry, the jury.
Going to a different issue, if we were to, I don't know how we're going to decide it, but if we were to agree with the argument about multiplicitous charges, what are our options in terms of how to deal with that?
Yes, Your Honor. I believe if you were to decide that one of these were multiplicitous, that the court here could strike one, and it would not need to be resentenced because the defendant was sentenced to the same amount of imprisonment for all of the charges, or the two that would matter in this case. And the only issue would be the special assessments that were put onto those, so we would have to strike those. However, in this case, they are not.
Is there case law that permits us to strike those special assessments and make those adjustments instead of sending the matter back for resentencing?
Your Honor, I believe there is, and it's in our brief. I just, at the top of my head.
That's all right. Okay. I thought there was, but I wanted to make sure.
Yes, Your Honor. I had it written down, and I must have taken it out. The other issue, though, the government would say is these were not multiplicious. You had two different SD cards, the 16 gigabyte, which was count one, and the 64 gigabyte was count two. The evidence presented at trial was able to show that the 16 gigabyte was possessed by the defendant as early as 2012 with child pornography on it. The expert witness was testified that the defendant pulled child pornography off of a Toshiba hard drive, which was not a charged device, but was found in a home later on, and put it onto the 16 gigabyte SD card. So he had it, he possessed on that device longer than he did on the 64 gigabytes. So the government would argue that for this... You
cited U.S. v. Thomas, I think, on that.
Thank you, Your Honor. I had it somewhere. But in this case, so the matter, or the actus reus, would be the 16 gigabyte and the 64 gigabyte SD card. So they are not multiplicious. And then
wasn't there an overlap, though, on the dates on those two? Was there one particular date that was common to both?
The common dates, yes, Your Honor, would be in 2017 when they were both seized in the home. Yes, Your Honor. And then in relation to the defendant's argument related to sentencing, the judge followed the pattern jury, followed the guidelines. He understood they were advisory. I believe he said at least 8 times throughout that sentencing hearing that these were advisory. And I know that the main objection the defense had there is the internet restriction. The defendant, once he is out of jail, that he has to go to the probation office to get approval to use the internet. This court has said that that is reasonable. And even in the sentencing hearing, Judge, the district court told the probation office, make sure any restrictions are reasonable. The defendant has 14 years to identify what areas of the internet he wants to use, so he can give a grouping to the probation office. so that the probation office can approve that prior to, him getting out and using the Internet. In that, Your Honor, absent any question, the government will rest.
Thank you, Mr. Paradiso. Mr. Starrett, you say time for rebuttal. Okay, Mr. Starrett.
Thank you, Your Honor. The question was asked, was this the vilest thing that you could show? And I listened very carefully to his answer, and his answer was, this was indicative of other things that the defendant possessed, and that's not in the record. The only thing that's in the record is the government statement that this is the vilest thing our investigators ever seen. That's in an email. It's attached in the record. It was in the defendant's motion to the court. Don't let them get in all this prejudicial stuff, and it came in anyway. So G64, they're stuck with their own words. This is the vilest thing we could have presented in this case, and they did. And it went back to the jury, and he says, well, there's no evidence that they did not look at it. I think, Judge Haynes, you're absolutely right. That's the point of putting something in evidence as opposed to ID. In evidence means it's in that jury room, and we know from the record in this case that the court said, jury, all you have to do to look at any of this stuff is tell the courtroom security officer directly. And so there's no provision in the record for the prosecution to say, well, we know that they didn't look at it. They set up a situation where it all goes to them. The court says all they have to do is ask for a device, and it'll be given to them, and we'll never know whether they looked at it or not. We know that this jury deliberated for 3.5 hours, and that's from the record pages 1117 and 1123.
Well, in federal court, you can't talk to the jury afterwards, so we would never really know.
Well, I mean, it could have been set up so, I don't know, send a note to the court if you want to look at it, and then we'll know whether you were looking at it or not. I'm not sure.
No, what I'm saying is in state court, a lot of times they do talk to the jury afterwards, so at least you might have some hearsay knowledge. I'm saying in federal court that is not the case, or it's rarely the case.
We don't know, and that's the government's problem. That is not the defendant's problem. When the government sets it up to go back to them like that, then they are responsible for everything they send into that jury room, and it was awful, and it was overwhelming.
But still, the question for the jury was, did he possess or did he not? If he didn't, it was because he argued the wife set him up. So if he possessed it, one or more images, that doesn't really go to how vile, reprehensible the images are. The question is, if it's child pornography, did he possess it? And obviously, the jury decided in the dispute between him and his wife that it was he.
I agree with you completely, and that's really my point. The government did not need to prove all these thousands of images, and they didn't need to prove the vilest they could. All they had to do was prove child porn. When it goes back to the jury, we do have to be concerned about, did that affect you? In the Caldwell case, which authorized sending back 3 videos in a case compared to thousands of images back in that jury room and the most horrible stuff you can imagine. So Caldwell and this case are not at all alike in terms of what back to the jury. But one of the factors in Caldwell that this court said what made them more comfortable about affirming that conviction was the trial judge in that case specifically cautioned the jury on the record, do not let your revulsion to this material influence you, prejudice you, and when you're deciding the facts of this case. That was done in Caldwell. It was an ameliorative matter. That was not done in this case. This judge did not tell the jury, do not let your passion about this stuff influence your verdict. The voir dire that the defense did that asked them about could it be so prejudicial that you couldn't be fair, the trial judge interjected to rehabilitate those jurors. But in that whole process, and this is in the court record at, bear with me. I don't have that slide, but he tells them during voir dire, it's in the beginning of the trial, during the defense voir dire of the jury, the judge, when he's questioning them about this, never says to them, don't let this unduly influence you, all right? So you got the poisonous stuff back in the jury room, no way to control what the jury looks at, and that was just unfair. Now, Judge Haynes, I agree with what you were asking, because I didn't understand it earlier on about one of the things that you were asking about isn't motive. Wouldn't motive be important? Wouldn't it be nice to know whether this is someone who is interested in children with sex or totally uninterested? Wouldn't that be nice to know? Because motive is an element. The government was allowed to put on their 3 prongs of the criminal stool.
Yeah, but y'all didn't have the expert do the testing that would have established, at least kind of in the lie detector world, whether he does get excited from child pornography or not. Just having experts go around and question friends, to me, is a little bit limited.
We don't know what they did to form their opinion. Now, he says, by referring to the sentencing stuff that was done, but that's irrelevant to the trial judge's ruling pre-trial about this.
So you did not offer evidence that they did that test?
No.
You all are the ones who are trying to get the expert in.
Well,
That's why I'm saying, if you had shown that, that would at least put you in a little bit closer to the issue, but not having that done, or at least not proving that it was done, I just wonder about that.
Judge, I don't know whether that had been done or not. I don't know.
Well, if you don't know, then you couldn't prove it to the district court.
Well, we could have if the judge had said, I'm going to lean in your favor if you'd show me some tests. Then maybe they had done them and could show them. But he made his ruling.
It's not up to the judge to tell you what your expert should do. You need to have your expert do it, and then you go try to persuade the judge.
Thank you, Your Honor. I see my time is up.
Yes, thank you, Mr. Starrett. Your case is under submission.